further hearing of the guilt of QX against the Secretary of State for the Home Department.
Cheers. It's good.
Yes, Mr. Squires.
Remember, please, the court should have received notes from
Yes,
the
we have
parties
that.
as requested. We have hard copies, but I understand they're not required. I ended yesterday dealing with Regner and the GNX school case.
Yes.
And first submission in relation to them is that our case is much more straightforward. We say, as I'll submit when we look at the statutory scheme, that in fact conditions A and B are conditions for the legality and necessity of the obligations. So we say it's a straightforward dispositive case in that sense. It's not, in fact, two stages at all, and I'll seek to make that good. But if one does take a Regner or GNX school case, we say it's still apparent that Article 6 is engaged. If one asks, as in Regner, is the imposition of a lawful TO a condition or a sine qua non for the obligations, the answer is plainly yes. And if one asks, as in GNX school, does a decision on condition A, TRA in Syria, have a major or substantial influence on the legality of the obligations? The answer is clearly it does, certainly on Mrs. Justice Farby's analysis, because that's the only opportunity you have to challenge the TRA allegation. Finally, on the Article 6 principles, I was going to deal with the Mauia case, because that's in effect, the high point of the Secretary of State's case. Is he says this is a Mauia incidental impact type case. And we respectfully say that is to misunderstand Mauia, and the reliance on it is misplaced. So the court, it may be helpful just to pull the case up. It's at page 2046.
Just before we leave RG, are you saying that the test, albeit that it's got to be somewhat flexible, is essentially that we should be asking ourselves, would proceeding A, would the imposition proceedings have a major or substantial influence on the obligations?
Well, if we're wrong, I'll come into our primary argument. In fact, you don't even need to go through that analysis, because we say conditions A and B are conditions for the legality of the obligation. So, in fact, a challenge to them is a challenge to the legality of the obligations. The GNX school case applies if one does think of them as two separate sets of procedures, and then one applies the major or substantial influence test.
Yeah, I wonder if it's quite so simple. It occurred to me, if you remember the Belmarsh case, restrictions, there was a particular regime for non-citizens. And at the end of the day, it was held to be unlawfully discriminatory. But just say there was a scheme which was a lawful scheme, but it only applied to non-citizens. You couldn't, I think, say that meant that Article 6 therefore applies to questions of citizenship, because the link, although it be a precondition for imposing the restriction under the regime that you were not a citizen, the link between the determination of citizenship and the application of the regime would probably be insufficiently direct, because obviously there are masses of non-citizens in the UK to whom the regime would not apply. But I think you would presumably argue that in the present case there is a very close link between the imposition of the TEO and the subsequent imposition of the obligations.
Yes, I mean, certainly when one looks at the conditions, we say they are, and particularly what will come on the facts of this case in particular, but no doubt in many others, that condition B for example, is entirely about the obligations in this case. The reason the TO was imposed was to impose the obligation. So in that sense, we say that it couldn't be closer. So if one does adopt the GNX school case, we would say could not be closer if that's what the GNX school has, a sort of range, which it says dispositive, it says merely tenuous, or more than merely tenuous, probably not enough. We do say.
So if in the G and the X school case, it had been, the regime had been that a barring decision or a hearing whether to bar somebody could only happen if someone had been dismissed from their employment because of sexual misconduct with a minor, then that might say be a closer analogy here. That his dismissal by the school was a precondition to the barring question being investigated.
Well, it might go further, we would say, in terms of the analogy. The analogy would be if the school's findings of fact would then bind the next decision making. The reason there wasn't a breach of Article 6 in the GNX school case is because the barring mechanism was able to make entirely new findings of fact. But if you had a situation where whatever the school had found, the barring body had to apply.
But that's not the position here, is it?
Well, it certainly is on Mrs. Justice Farby's analysis, and we'll come on to what the Secretary of State's new case is. Mrs. Justice Farby's analysis was you can only challenge the Syria allegations in the imposition review. That's why you don't get AF number 3 disclosure in relation to it. By the time you then get to the obligations, you can't then go to the obligations review and say, but I wasn't in Syria. I wasn't involved in. So in that sense, on her analysis, that's why she held QX didn't get AF number 3 disclosure, because you could only challenge the Syria allegations at that first stage.
Is that right? She said you can only challenge conditions A and B, but there'll be an overlap in the evidence, and the evidence of the Syria allegation may well be part of the context that relates to the imposition of the obligations, and you will be able to engage with and challenge that.
Well, we said that isn't what she held, because otherwise it would make no sense of her saying he wasn't entitled to AF number 3 disclosure.
I'm not sure that's right.
Of the Syria allegations. It's in, the analysis is in, we put it in our note from this morning. It's the third judgment. Paragraph 29, which is 166, 28, where she explains how you can challenge the national security case. It's the final sentence. No bar to claim challenge those aspects of the national case that are relevant to the Secretary of State's assessment, the obligations are necessary and proportionate. September ruling, paragraph 25. And if one goes back to that, she explains what she means in the last sentence.
So the page number, sorry?
Sorry, 157. What you can say is, you can challenge the assessment they remain necessary and proportionate despite the passing of time or the claimant's changed personal situation.
What paragraph and one?
25, the last sentence, which
Yes.
she was referring back to.
Yes, I mean, the reference to LG was in the Secretary of State's submissions to her,
Yes.
where they did seem to say you have to take the national security case at its highest. You can't challenge the basis of the T.
In an obligations review, you have to do it through your challenge to conditions
By the
A.
Section 16 review of a TDM case, not challenging the
Precisely, you're just challenging the obligations. So you can challenge the national security in the sense you can say, well, passing of time, my changed personal situation means it's no longer necessary to have me, which is what QX was in fact. One, he is arguing as part of his obligation review, but her decision, and this is why all of this came up, was in relation to the Syria allegations. They can only be you can only say I was not involved in terrorism-related activity if you're challenging condition A, which she said that's part of imposition. Therefore, Article 6 doesn't apply. Therefore, you don't get AF number 3 disclosure, or not. So you're not entitled to AF number 3 disclosure.
I'm beginning to wonder, something Mr. Tam and I will come to in due course, as to whether the Secretary of State's position is a coherent one. Because, as I understand it, the Secretary of State does accept now, whatever Mrs. Justice Farby may have held, the Secretary of State now accepts that the Syria allegation, if it forms part of the justification for the imposition of the obligations, is something which can be examined in the obligations review. But a point that is emphasized in the Secretary of State's note this morning is that the evidence may not be the same as the evidence considered in an imposition review. And I wonder if that is a coherent position. I mean, it would open up the possibility of a court taking a different view of whether an allegation had been established in the imposition review from the view it took in the obligations review.
Well, yes, I was going to comment that. We do say that Mrs. Justice Farby's position analysis, we respectfully say is wrong, but we say it's coherent. What the Secretary of State's position, at least now, appears to be that you can go into the obligations review and say, I was not involved in terrorism in Syria, therefore none of this was proportionate. And you can say the same thing in a challenge to condition A. And the evidence, he says, may be different because AF number 3 may only apply to one but not the other, and that means, for example, he may decide to withdraw reliance on some material. So in the same case, you'll have two findings of fact about whether QX was involved in terrorism-related activity in Syria, which may be different, and that cannot possibly be correct.
Yes, and if that is a problem, then that may be a clue as to whether the basic argument that different evidential rules apply at the two stages is a sustainable argument.
Yeah. Well, and our submission is it is much more straightforward. It is simply that you are challenges to conditions A is a challenge to the lawfulness of the obligations.
And so that Article 6 is engaged if those obligations interfere with a civil right.
Yes, that's right. It's exactly the same with control orders, etc. You only get Article 6 because the obligation interfere, and therefore you are challenging them. And one of your grounds of challenge is, I was not involved in terrorism-related activity, condition A not met. I was just going to turn to the Mauya case to make a short submission as to why we say it is of no assistance here. Page 2046. And the relevant paragraph here, you will recall, was paragraph 38. This is a...
Sorry, what page is paragraph 38?
Yeah, apologise. It is 2054. And the issue here was deportation of aliens fell within hardcore public authority prerogative. What the Strasbourg court was concerned with is that you can't get round that by saying, oh yes, but the deportation had incidental effects. So one of the byproducts of it is, and you see the last sentence of paragraph 38, incidentally had major repercussions on private and family life, prospects of employment. So for obvious reasons, you can't get round the fact that deportation of an alien isn't within Article 6 by saying, oh yes, but it affected my job prospects. And we say that has no application here. This isn't an incidental effects case at all. You can see what an incidental effects case would look like in this context. For example, if, assuming, as I do for my first argument, the right of abode is not a civil right, suppose a TO is imposed on QX or imposed on another individual not being deported, and they come back to the UK under a permit of return, but it takes a while to get them the permit of return, and no obligations are then imposed on them. What they would not be able to say is, well, the delay getting me a permit of return meant I lost my job, or meant I missed out on a family wedding, or something like that. That would be an incidental effect, a byproduct case. But this simply isn't that case. That isn't. He's not suggesting that it's the incidental byproduct of any interference with his right of abode, his delay getting back into the country, that gives rise to the Article 6 right. It's the challenge to the obligations. That's nothing to do with incidental effect. And the other case is MAFTA, is another example of the same thing. It was a challenge to a decision to nominate by the UK Foreign Office as a member of the Security Council, to nominate people to the UN for asset freezing. They then had their assets automatically frozen by an EU regulation. And you can entirely see why the Court of Appeal would say, well, look, that decision, what the UK does as a member of the Security Council, is hardcore public authority prerogative. Mr. Maffitt and Carter couldn't get round that by saying, well, the asset freeze incidentally affected the byproduct of it was interference with our civil rights. Those are the legal principles. Turning now to their application, I was going to go to the statutory scheme. And our case on the statutory scheme is this, essentially, is that a TO has two purposes and allows the Secretary of State to do two things to an individual: to protect the public from the risk of terrorism. And those two purposes are to control return and to impose restrictions on the individual after they return. That's the purpose of this whole regime. That's the purpose of imposing a TEO. And we'll see in some cases we may be more concerned with one aspect. In ours, a deportation case, in fact, we're concerned with imposing obligations. But those are the two purposes of imposing a TEO. And our case is that conditions A and B are critical to the legality of both. They're critical to the legality of interference with the right of abode, but they're equally critical to the legality and necessity of the imposition of obligations. They're critical to both aspects of the TEO. If it wasn't reasonable to suspect someone of involvement in terrorism, there'd be no basis for imposing obligations on them. That's why we say conditions A and B are central to both the TEO's purposes. That's why we do say, with respect, it's not clear it's helpful to think about an imposition stage, an obligation stage, when one's thinking about the role of conditions A and B. They are critical to both of the aspects of the TEO. And just turning briefly to you have seen the statutory regime, but it's page 986. And just to make a few additional observations about the statute, you'll see that 2.1, a TEO is an order that requires an individual not to return to the UK unless permit of return or deportation. So in fact, in a deportation case, it's not clear that the TEO is going to be controlling return at all.
How does it work in a permit to return case? How does the individual know to apply for a permit?
I don't know. I suppose they must have the order must be served on them in some way, I assume. I don't know. So the only case I've ever come across, in fact, being deportation case, including this one. So I don't know what the...
The order in this case was served on his legal representative.
I think it was in this...
And I don't know the provision that allows that to take place. But anyway, not to worry.
Yeah.
It's a point of...
So that's the order. So I say it controls return in non-deportation cases. You then have the conditions, and the court will see 2.8, which we'll come back to, is a requirement to continue to determine whether condition B remains in force. And we'll see in a moment that is going to be in a case such as the present while once the person's back in the UK. So you're continuing to have to decide if condition B is met, and at that stage it's going to have nothing to do with controlling their return. They'll already be back, but the Secretary still has to consider condition B, and we'll see in a moment that will be largely about the necessity of continuing to impose obligations. It certainly won't be about controlling return once they're back in the UK, but 2.8 still applies. Secretary still has to consider, should I continue with the TEO? Section 9 is the obligations provision, and one sees 9.1a. Again, the power to impose obligations is only if someone is subject to a TEO.
Right.
And we would say clearly it has to be a lawful TEO. That's one of the conditions. That is the condition to imposing obligations. Section 10 deals with the offences, and you'll see there's two separate offences. There's the return offence, 10.1, and there's then breach of obligation offence, 10.3. And if you turn to the criminal provision, the criminal quashing provision at page 996, you'll see that an individual, paragraph 1.1 and 1.2, an individual is able to appeal against a conviction for breach of the obligation both if the TEO itself is quashed, 10.1, but also if the obligation is quashed. It's not only if the obligation is quashed, it's also if the TEO itself is quashed, 1.1, that you can appeal against.
So why did QX here feel he had to get the TEO quashed rather than just apply to have the obligations quashed?
Because well, he originally did try just to have the obligations quashed, but as we've seen, in order to challenge the terrorism-related activity, the condition A, he has to also apply to have the TEO quashed, because that's where you can challenge condition A, is in a challenge to the TEO. So when he amended his case, so he wanted to challenge the Syria allegations, he was then challenging condition A. The initial individual obligations being quashed is generally when one says, well, I've lost on condition A, but 7 days a week was too much.
Which I know, but one of the things we've been exploring is whether that's actually right, or whether you could, in the context of a obligations review, challenge condition A. That's what those notes were.
Yeah, I mean, if one can, then this may all become, I mean, if one can challenge a condition A in the obligations review, and the answer is, well, it would seem odd. It would seem odd that the TEO is then not itself quashed, because if you've succeeded, but in principle, at that stage, it may then make no difference if you can challenge conditions A and B in the obligations review.
But the court can't quash the TEO in that situation.
No, it can't. So that's why it does seem odd. It does seem a much more natural reading, which is exactly how it works in the control order context. Control order context, we'll see in a moment, the statutory regime is very, very similar. Say, we'll see in a moment, that for the permit of return part, though even that we'll see can apply. One can challenge the TRA case and get the whole control order quashed, as well as then challenge individual obligations. They're different statutory, different parts of the statute. Finally, just a note on paragraph 11, section 11, which is at 992. 2 points which I'll come back to. One is a point picked up on yesterday, but that one can only challenge the TEO under section 11 once the person's back in the UK, and I'll come back to the significance of that in a moment. But otherwise, when we compare this to briefly the controller and TPIM scheme, what you will see is that all of them have the same structure, which you can challenge the conditions for the imposition, conclusions that it was necessary to impose, conclusions on TRA, and then you can also separately challenge obligations. All of them have the same structure. As I say, generally the way it works is initially you say not involved in terrorism, may lose on that, may then say, well, okay, not necessary to impose the order at all, may lose on that, can then still say, well, even if I lose on all of those, 7 days a week was excessive, should have been 5. They all have the same structure. And I want to make now 4 submissions, if I may, about the statutory schemes. The first is the one I've already highlighted, is that TEOs have 2 purposes. The imposition of a TEO has 2 purposes. It's wrong. The way it was presented was as if the imposition of a TEO's purpose is only about controlling return. Obligations then a separate phase. It's not. The purpose of imposing the TEO is, if necessary, to control return and to enable the obligations then to be imposed. And we'll see that particularly clearly in this case, given that it was a deportation case. That was in fact the reason that the TEO was imposed. If the court has paid 800 of the electronic bundle, this is the submission to the minister recommending the imposition of the TEO. So this was, you'll see the date, 22nd of November 2018. It was a few days before the TEO was imposed. And you'll see where it says pressing, timing pressing, QX is currently in Turkish detention facing deportation. The TEO is therefore required to ensure we have the necessary safeguards in place for when QX returns to the UK.
It was clearly contemplated that he might seek to return or be deported.
Yes, I think at this stage, he's facing deportation.
Well, it says the urgency is because he might seek to return or be deported. That's Little Roman 2 under recommendation.
Yes. Yes, Ms. Mayor is absolutely right. And then over the page on discussion, there's a reference to, we therefore request you consider imposing on QX to help mitigate the risk he might pose to the public on return to the UK. And a list of paragraphs 19, 20, you see the kind of in-country obligations that can be imposed, and in fact duly were imposed on QX.
Which page, sorry?
Page 804. And we see something very similar in the witness statement that was presented to the court by the Home Secretary in order, the court's permission is required. Page 470 of the electronic bundle, you'll see the witness statement from Laura Waite.
Sorry, what page?
470. At 470 it starts. 472, you'll see the heading, Reasons for Imposing TEO. And you see flicking down paragraph 6, security service assessment. 7, there's the national security case against him, travel to Syria, reasonably suspected, is or has been aligned with an Al-Qaeda aligned group. Why that shows paragraph 8 that he poses some danger, and why the TRA condition is satisfied, paragraph 8. And then paragraph 9, as the respondent is reasonably suspected to have been involved in TRA, taking account of the risk that those alleged with an Al-Qaeda group pose to national security, the Secretary of State is satisfied that proposed measures are necessary for purposes connected with protecting the public in the UK from a risk of terrorism. It says paragraph 13, but I think that must be a typo. It must mean 11, because that's where the measures are set out. So again, we say nothing unlawful about this, but what the concern here is primarily, if not solely, with having the TO in place so that the obligations in paragraph 11 can be put in place. And the reason they are regarded as necessary is because of the terrorism-related activity allegation. And you can see why they say the obligations will help meet his risk. And so we do say two things about this. What it shows is the obvious connection between condition A and the obligations. It's because of the TRA case that the obligations are regarded as necessary, and also in relation to condition B, the reason the TO here is regarded as necessary, at least, is primarily, it's not suggested, at least here, that it's necessary so that we can control his return, presumably because it was a deportation case, but it's necessary so that we can then impose obligations on him. So that's why we do say challenge conditions A and B are critical to obligations, not solely, and in this case, not primarily, to do with controlling and managing a return and the right of abode. And that's my second point about the statutory. That's why we say conditions A and B should not be understood, we say, as being concerned with solely interference with the right of abode. They are concerned with both. They're critical to the legality and justification of both. Any interference with the right of abode, or in a case such as this one, where there may be minimal interference with the right of abode, but the Secretary of State wants to impose obligations on return. Third point about the statutory scheme relates to the Section 11. The fact that Parliament has legislated that it is only on return that an individual is able to challenge the TO. Now, at that stage, of course, any interference with the right of abode in terms of the individual's return will have been complete. And indeed, if no obligation had been imposed, it'd be slightly hard to see why a TO would continue.
Is that right? You control their coming and going.
It may.
What? And they would have to have some form of authorization if they were to travel.
Maybe that's right. The only question would be there are more proportionate ways you can remove someone's passport without requiring a TO. But I take that. I entirely accept that. There may well be reasons to continue with the TO. But it's also the case, certainly if one's thinking of a TO as about at least controlling the initial return, that will have finished. And certainly in many cases, the primary concern of the individual will be at that stage the obligations.
Well, Laura Water talks about the importance of limiting his opportunities to travel and take part in extremist-related activities.
Yes, it may well be a continued. I accept that, but I say we do say it's a say. There's a short point is just that it is notable that the review, at least certainly, doesn't take place at a stage when a person could challenge the initial interference with his right to entry. And it is correct there will be continuing interference with his right of abode, but there will also, obviously, at that stage for many people, be obligations, which may well be the focus of the Section 11 review. Fourth point concerns the structure of the review process, and a significant part, both for Mrs. Justice Farby and the Secretary of State's, Mrs. Justice Farby's analysis in the Secretary of State's case, is the split between the fact that there's different elements to the Section 11 review. There's an obligations, what's described as the obligations review, and there's other 11. You've seen in 11.2 the different strands of it. Our case in relation to that is that can't affect, as a matter of substance, what is being decided. That would be a classic excessive formalism. Recall what was said in the G&X case, the fact that as a matter of form, different processes are separate isn't the issue.
But the court has different powers. Doesn't that make a difference? In an obligations review, the court can quash obligations. In an imposition review, the court can quash the imposition. But
and the obligation.
Vice versa.
Correct, but the court can also quash the obligations in an imposition review.
Well, they would fall away.
But
the court can only quash the TEO.
It can only quash the TEO,
Yes.
which the consequence.
So, I'm just asking, doesn't that make a difference to the analysis? You said this is just this is not looking at substance, this is formality.
We respectfully say no, it doesn't make, or our submission is that it doesn't make a difference because both of them are challenges to the obligations. They're two different ways. There are different ways individuals can challenge the obligations in a TEO case, exactly the same as control order TPIMs. They can say, I was never involved in terrorism, shouldn't have imposed this order on me at all. They can say, well, even if I wasn't necessary to impose the order. They can say, well, even if I lose on that, the obligations are excessive. And we do say that each of those challenges are challenges to the legality of the obligations. It's not the case that it's only the third that is a challenge to the legality of the obligations. It is a challenge to the legality of the obligations to say, I was never involved in terrorism, you should never have imposed a TEO on me in the first place. And it's exactly the same with control orders and TPIMs, we say.
You mean substantively, not formally?
Yes, precisely, yes. As a matter of substance, that is a challenge to the legality of the obligations.
Because if the TEO is quashed, then the obligations will.
Yeah. It's different. The obligations review tends to be a challenge to an individual obligation, which is again why the remedy there will generally be this individual obligation is quashed. If the person simply, there was no basis to suspect them of terrorism-related activity at all, then the answer is the whole thing is quashed, which include all the obligations and the TEO itself.
But that's not a result that can come out of an application simply to review the obligations.
Correct, lady. And again, exactly the same in the control context. If you only say these obligations are excessive, normally this particular obligation was too much, that might be quashed. But it's only if you say, I wasn't involved in terrorism at all.
I think Mr. Tam was suggesting yesterday that if the outcome of the obligations review was to raise a serious question about the imposition, you could reopen the imposition. So, in effect, going round in circles.
Yeah, which is part of the difference I will come to, but the practicality.
But what about 11.6? Easy, except there's the notice. That's this notice, that's not the T.
Yes, that's the notice. This contains the obligations. Turning briefly then to the application of the principles to the issue in dispute, which is, does a challenge to condition A and B engage Article 6? I've already made my submission. If one applies the regular test and asks, is the result of a successful challenge to condition A directly decisive of the legality of the obligations? The answer is yes. If you put it in Article 8 terms, the obligations will have been imposed in a way that is not prescribed by law if the TEO itself was unlawfully imposed, and will also clearly not be necessary if someone succeeds in quashing condition A, succeeds in establishing they weren't involved in terrorism-related activity. The answer is it plainly was not necessary in Article 8 terms to impose obligations on them. And we say it's equally clear in relation to condition B. If you can establish it wasn't necessary, and in particular if one thinks of this case, if QX is able to say, well, it wasn't necessary to impose the TEO, you didn't need to impose obligations on me, that being the main rationale for it, certainly at the outset, or one of the rationales for it, that is a challenge to the obligations. The obligations will be quashed. They will be found to have been unlawfully imposed. They'll be found to be imposed pursuant to unlawful order. Similarly, the continuing application of condition B. And our respectful submission is that isn't surprising that challenges to condition A and B should be directly decisive in that way. If one goes back to the twofold purpose of a TEO, control the return of the individual and to allow obligations to be imposed, conditions A and B underpin both elements. They underpin the legality of interfering with someone's ability to return. They also underpin the legality of and the justification for imposing obligations on them after they return. So we say, with respect, it's not surprising that if you challenge them successfully, you are challenging both the interference with your right to abode, if there has been one, and the interference to which the obligations give rise.
So what do you say about decisive one way or another point?
I was going to come on to that, if I may, when I deal with the Secretary of State's, but I will deal with that if I may at that stage. The second argument we make, which we set out in our written case, paragraphs 40 to 49, is we say TEOs for these purposes are indistinguishable from control orders and TPIMs. Given the time, I won't take you through the three different regimes, but essentially they share a number of clear similarities. They have very similar conditions for their imposition. There's a reasonable ground to reasonable suspect for a control order involvement in TRA, reasonable belief in a TPIM. There's then a second stage necessary to impose the order. TRA is defined identically in all of them. All three allow what can be very similar, if not identical, obligations to be imposed on the individual within the UK. And we've seen in the control order context, there are specific obligations restricting someone's movement to the UK. So there's no reason why, for example, in a control order case, one couldn't initially impose a control order and say, this is how you have to come back to the UK. Subsequently, when the person returns, impose obligations on them. That would be identical to a TEO. And what is clear from the authorities, and is not disputed, is that Article 6 is engaged in challenges to control order and TPIMs, not only in relation to the individual obligations, but in relation to the imposition of the control order or TPIM itself, on the basis that it was not reasonable to suspect the individual was involved in terrorism. And they all, I should also say, all of them have very similar mechanisms for challenge. They all have a possibility of challenging what is in effect condition A. They also have a mechanism, the TRA, they also have a mechanism where you can challenge the individual obligations. And they also have very similar mechanisms in terms of criminal sanction and appeal. And the rationale it's generally been assumed or conceded that Article 6 applies to the challenge to the control order of TPIM itself. But the reason for it must be, and we see the BB and BC analysis where you have to show there's civil rights engaged, if some of the obligations of a control order, say, interfere with civil rights, the reason that a challenge to the control order itself engages Article 6 must be because that challenge to the control order is directly decisive of the legality of the interference with the civil right.
So is the situation the same as you accept it is for TEOs, that a control order, a challenge to the imposition of a control order or a TPIM will only engage Article 6 if the obligations that have been imposed under those regimes engage Article 5 or Article 8?
Precisely, yes. So, or engage civil rights. So, for example, you could have a control order or TPIM, which, at least on the Secretary of State's analysis, doesn't engage. It could only stop the person leaving the country, remove their passport, if that was the only concern. That could be the entirety of the control order or TPIM. The answer then would be it wouldn't engage Article 6. If, however, there are obligations that engage Article 6, it is absolutely clear that the challenge to the control order or TPIM will engage Article 6, and that can only be because the result of that challenge is directly decisive in Article 6 terms. And I'll come back to this in terms of the one way or another question, because all the one way or another analysis applies identically to control orders. And I won't take, we put the references in our printed case. I won't take you to them given the time, but what's quite clear from AF number 3 is that the whole reason that was entitled to AF number 3 disclosure is because of the connection between terrorism-related activity, the allegation of terrorism-related activity, and the obligations. It's because the obligations are justified by the allegation, but all of the concerns about the rule of law, about imposing onerous obligations without telling people, without giving people a fair opportunity to answer, arise. It's because of that connection. And we say so it must apply equally to TEOs. They can be the same obligations, must be the same requirement. Fairness must have the same requirement to tell people enough about what they've done to enable them to challenge those obligations. The Secretary of State seeks to distinguish the control of the TPIM regime. He says, in contrast, this is 2.9 of the, 2.10 of the Secretary of State's printed case. In contrast to the two-stage scheme of TEOs, neither controllers or TPIMs have any separate life from the obligations they impose. 5.7, he says, controller teams are one-stage scheme in which the obligations are directly under challenge in any review. But we say the answer to that first is that doesn't deal with the issue of principle. If one goes back and asks why is Article 6 engaged in control or the TPIM cases, it must be the analysis I went through. You have at least some obligations that engage. You saying you should not have imposed the order on me because I was not involved in terrorism is directly decisive. Now that logic must apply equally here. But secondly, we do say that distinction is, again, going back to the Lord Dyson in the G case, the excessive formalism, giving too much weight to form over substance. The fact that one imposes the TEO, the fact that the TEO has another function, controlling the return, cannot change the analysis as a matter of substance as to what you're entitled to be disclosed if you want to challenge the same obligation.
Yes, sir.
It can't be that timing question, the fact that TEO is imposed initially when the claimant here is in Turkey and then comes back, that can't affect as a matter of substance what fairness requires if he says, I wasn't involved in terrorism. I need to know the case against me.
Okay.
And of course, a control order could operate in exactly the same two-stage way as we saw. It could be that the only obligation, if someone was abroad, was to do with controlling their return, and then further obligations are then imposed. And it's clear that wouldn't avoid the Secretary of State. The Secretary of State couldn't therefore avoid saying, well, when you challenge the TRA case, you're not entitled to AF number 3 disclosure. Or in fact, you could even imagine tweaking the control order regime very slightly. So for example, if you said every control order had to stop individuals leaving the country, which I think almost all of them do, and then the Secretary of State had a subsequent power to impose whatever obligations, residence requirements, reporting, etc., the regime would then be a two-stage process, but it could be absolutely identical. It can't be right that that fundamentally changes. If you had a slight tweak to the regime, that would fundamentally change whether AF number 3 applies, whether Article 6 again.
Had it been established before the TUTO regime was enacted that Article 6 was engaged in a challenge to a control order or a TPIM if the obligations interfered with somebody's civil rights?
Yes, I mean, that is, it's MB. I think we put the references in the written case. It was originally based on a concession by the Secretary of State in MB, accepted that at least some of the obligations, the concession was at least some of the obligations in MB's control order interfered with his civil rights.
But if the Secretary of State didn't concede, if the Secretary of State wished to argue that the obligations or restrictions, if they're in a TPIM, didn't interfere so intrusively as to engage Article 8, what would happen? How would you?
That was the BB and BC case. If anybody recalls, it was in the judgment of Mr. Justice Farby, the sort of Mr. Justice Collins judgment. That's exactly what happened. The Secretary of State came along and said, well, these are sufficiently non-intrusive. Yeah. Article 6 is engaged, we don't have to make AF number 3 disclosure. Now, that might have succeeded, but on the facts, the obligations were regarded as being sufficiently intrusive by Mr. Justice Collins, so Article 6 was engaged and AF number 3 disclosure applied.
So in every case, you'd have a sort of preliminary inquiry as to the extent to which the obligations or restrictions interfered?
If it's disputed, yes. In fact, exactly what we had in this case when it was just the obligations review. One had exactly that. If it's disputed, you have a preliminary hearing and decide. Our third argument of why we say the Secretary of State's analysis and Mrs. Justice Farby's can't be correct is we do say it leads to incoherence. Firstly, the analysis, Mrs. Justice Farby's analysis, which we had understood the Secretary of State to be supporting, which was you can't say I wasn't involved in terrorism-related activity in Syria in the obligations review. You can only do it challenge condition A. That leads, we say, to the incoherence of someone. If someone comes along and says, well, you've misunderstood the national security case against me, I wasn't involved in terrorism-related activity at all, the answer is, well, that's a condition A challenge. If they come along and say, well, you've misunderstood the national security case against me, I wasn't a senior leader in Al-Qaeda, so I'm not challenging the TRA case itself, but I am challenging the details of what you said I did, they would then be entitled to AF number 3 disclosure, because they would say, well, I wasn't a senior leader in Al-Qaeda, therefore 7 days a week of reporting wasn't justified. On Mrs. Justice Farby analysis, that's now an obligations challenge. You would get AF number 3 disclosure, but that can't be correct, we say. You then have what we now understand to be the Secretary of State's position, which is that, in effect, you can come along at the obligations stage you can both at the condition A stage and the obligation stage, you can run exactly the same argument, which is, I was not involved in terrorism-related activity, therefore you shouldn't have imposed the TEO, and therefore 7 days a week reporting is not justified. And the difficulty with that is either one is dispositive of the other, the initial decision is dispositive, you decide it once, and then you apply it again. That will be a classic G and X school case. You've already decided it, so I'm going to make the same conclusion. Or you end up with a position which was raised earlier, that you can have in the same case with different evidence to directly inconsistent findings of fact.
I think in the note that we got this morning, the Secretary of State does accept that if the same hearing is dealing with a challenge to the TEO and a challenge to the obligations, then in effect there will be AF3 disclosure, which may well influence the own imposition challenge.
Well, as we understood it from 9 to 11 of the note, it was suggested that because AF number 3 wouldn't apply at the condition A stage, there may be different evidence that would be applied. For example, at the AF number 3 stage, the Secretary of State is able to withdraw evidence rather than disclose it. So I think the analysis would be at an obligation stage, AF number 3 applies, the Secretary of State decides not to rely on certain evidence, withdraws it, wouldn't apply at the condition A stage. So you could get, I say, if you're always going to get the same outcome, then the answer is that's dispositive. If you could get different outcomes because you're relying on different evidence at the different stages, then that is obviously incoherent. The same judgment would say, I found he was involved in terrorist-related activity, no, I found he wasn't. And our respectful submission is the analysis is much more straightforward than that. It is that conditions A and B underpin the legality of both interference with the right of abode and any decisions to impose and maintain obligations. And therefore, a challenge to conditions A and B will be a challenge to both. And the fact that it is a challenge to both can't possibly stop Article 6 being engaged, because that will happen routinely in control order cases. There will be some control order obligations that will interfere with civil rights, others you can't leave the UK that don't. The fact that you're challenging both can't possibly stop Article 6 being engaged if some of the obligations, the fact that here the way in which the right to abode interference works is slightly different. It works through the passport cancellation, etc., can't change the analysis.
But does it often happen that the hearing is both a challenge to the TEO and a challenge to the obligations as a fallback?
Yes, I think that would be the general. The only reason it didn't in this case is because QX didn't initially feel able to say anything about what happened in Syria. Certainly, it routinely happens in control order cases. One comes along and runs, says, I wasn't involved in terrorism.
But there's only one review stage there. There aren't two review stages in a controlled order case.
But the same in the TEO case. There
are two separate reviews with different powers attached to them.
But that's the same in the control order. Yes, the control order regime. The control order regime. A person comes. There's a Section 310 review. At that review, the court reviews both the decision to impose and the individual.
Single review.
Right. But this will be a single review. It depends if the person comes along and says in Section 11, I want to challenge imposition, I want to challenge conditions A, conditions B, and the proportionality of the individual obligations. That would be one hearing.
Yes, but two different review procedures invoked.
Two different parts of Section 11.
Yes.
But then that is exactly the same as control orders. If
so what page is Section 310 at?
310 is page 1035 it starts, 1036, (310), the court reviews whether the decision, the requirements of 21A and B were satisfied. That's the 21A is the equivalent of condition A, 21B condition B, and separately 10B, the decision on the imposition of each obligation imposed by the order. And then one again has the same suite of powers at section 12, and quash the order, quash one or more of the obligations, etc. So we do say it will be the same. The only difference is that a control order, the review is automatic, whereas section 11, a person has to ask for it, but there's no reason at all why they can't ask for exactly the same structured review. In fact, one commonly would say, I wasn't involved in terrorism, and this was disproportionate. It's exactly the same as the two parts of 310. 310A is the equivalent of the imposition. 310B is the equivalent of, or if it is, the obligations. 21A and 21B, if one looks back, that is the conditions for imposing, which is page 1034, reasonable grounds for suspecting is or has been involved in terrorism necessary to impose, necessary to make a control order, and then you can then separately challenge the specific obligation. So we do our respective, that is the same, exactly the same structure. The only difference is it's automatic, whereas section 11, the person asks for it. Responding to the Secretary of State's argument, the Secretary of State makes arguments, this is 5.2 to 5.8 of his printed case of, or written case of principle, which we respond to at 54 to 60 of our written case, and our arguments of practicality, which he makes at 5.9 to 5.19, which we respond to at 61 to 65 of our written case. The first argument, the principle, is the Mawia incidental effect one, and I've already dealt with that. Conditions A and B, this isn't an incidental effect argument. It's not the consequences of the byproduct that we're complaining about. It is conditions A and B, which are conditions for both interference with the right of abode and interference that arise from the obligations, and the fact neither is incidental to the other. They're both separate consequences of the imposition of a TEO. Next was the non-determinative, non-dispositive point that I said I deal with. As well as studied, it appeared to be made in two ways. The first was not dispositive because the individual might lose the case, but of course that always arises. Any time anyone challenges says that there's been a breach of my HRA rights, they may succeed, they may fail, but that obviously doesn't determine whether Article 6 will still be engaged. The fact that you may lose, which always arises, you may not be able to establish an interference, doesn't mean Article 6 isn't engaged. Otherwise, I say it would never be engaged. The second argument is it said this is 5.5 of the Secretary of State's printed case, page 42. Not determined because the obligations may still be quashed in obligations review, even if the TO itself is upheld in an imposition review. The imposition review is not determinative whether the obligations will stand. So the argument is that QX may fail to establish conditions A or B were not satisfied. He may fail to establish that it wasn't reasonable to suspect involving terrorism, but he may then he may fail to establish conditions A or B were not satisfied. So he may fail to show it wasn't reasonable to suspect him of involvement in terrorism.
So that if conditions A and B are made out.
Yes, they are. Yes, but precisely. Sorry, yes. So he's failed to successfully challenge them. It's then said, but he may still be able to come along and say these obligations were disproportionate. Shouldn't have been 7 days a week. Should have been 4 days a week. therefore it is said not directly decisive. And we say with respect that cannot be right. The fact that you've got two different arguments, either of which, if they succeed, will quash the obligations, cannot mean that neither is therefore determinative. Once in an HRA case, one might say, well, this isn't prescribed by law, or might fail on that, but still be able to succeed on necessity. It doesn't mean that because you have a second argument that might succeed, the first isn't determinative. And of course, if that argument is right, it will mean Article 6 isn't engaged in the control order context when challenging the conditions for imposing the control order, because it works exactly the same as I showed you in section 310. One might fail in 310A because the conditions were met, but then succeed in a 310B argument. Shouldn't have been required to report 7 days a week, but that can't mean, that obviously doesn't mean Article 6 isn't engaged, because you've got a second potential way of winning. The third...
But it does, if one was focusing on the question, is the imposition review and the challenge to that dispositive, that would imply that it answers the case either way, whereas you're accepting that that may not be the case, because of course the actual application may be unsuccessful. But doesn't that mean that the question as to whether it's dispositive is not the question we should be asking ourselves? We should be asking, should we not, whether it might be dispositive?
Yes, that may be the way of doing it. Maybe capable of being dispositive. I think that was the language in some of the authorities. But I say that must be right, because it implies, I say, to control orders and lots of other contexts where you might succeed. You might succeed in one argument, fail, have another one. So yes, I accept that. I think capable of being dispositive, I think, was the language. The final argument principle was, it was said, if QX's analysis, or was the Court of Appeal's analysis, is correct, the criminal limb of Article 6 ought to apply, because the consequence is the criminal conviction is quashed. We again respectfully say that's not a good argument. The fact that the quashing of an administrative order means that a criminal conviction that follows from it is quashed doesn't mean the criminal limb of Article 6 applies. And we know that from the control order proceedings. The House of Lords in NB held that criminal Article 6 did not apply to control order cases, despite the fact that it operates in exactly the same way. A criminal conviction will be quashed in exactly the same way as under the TEO scheme. So we say that isn't a good argument. And of course, it would apply even on the Secretary of State's analysis to an obligations review. But if one succeeds in obligations review, the criminal conviction will be quashed. But again, no one is suggesting that therefore the criminal limb. Finally, in relation to the first argument, were the arguments of practicality, which are in the Secretary of State's written case 5.9, 5.19, to which we respond paragraphs 61 to 65, and which Mr. Gray dealt with orally. Briefly in relation to those, firstly, if we're correct, or if the Court of Appeal was correct as a matter of principle, the fact there may be case management issues that flow, we say, isn't going to determine the matter. But in any event, we say none of the arguments about practical consequences are good ones. Firstly, they all arise in any event in TEO cases, given what's accepted, in where it's accepted Article 6 bides. Two, they're equally likely to arise in control order or TPIM cases. And three, they in fact only arise in a very narrow category of case, which is extremely unlikely, not impossible, but unlikely to arise in practice. The only circumstances where all these concerns arise, if someone is placed on a TEO, comes back to the UK, has no obligations imposed on them, or very mild obligations, a review starts, they still decide to begin a review, and then later on, more onerous obligations are imposed such that Article 6 becomes engaged. Now, it's not impossible, But I would have thought it's pretty unlikely, because normally it works the other way. It's someone coming back from Syria. You begin with the high level of obligations, and you might reduce them. It's not impossible that one would start without obligations and then a year later impose them, but that is the only...
That was the question my lady was asking, which was a question I'd been wondering, whether the TEO is imposed whilst the person is still in Syria and may last for some time and is without obligations unless and until they decide to come back to the UK, and may expire after 2 years if it's imposed and they decide to stay in Syria. But then they can't challenge.
They can't challenge them at all. So that situation, the only situation where this difficulty would arise is someone comes back, obligations aren't imposed, or very minor, they still decide to challenge it later on. More obligations are imposed. Because in all other cases, one is going to know at the outset whether Article 6 is engaged or not, and if there's dispute, there can be a hearing about it. And that will be that. And of course, all of these concerns apply equally. The two sets of concerns are, one, some TEOs will have Article 6 engaged, others won't. Well, the answer is yes, and that's exactly the same with control orders. It's exactly the same in any of these sorts of measures. The other is things can change during the course of a review. Again, exactly the same applies to control orders and TPINs. One could have a control order that's imposed which has only restrictions on the person leaving the country, but later on other obligations are imposed. One would deal with that through sensible case management, but it certainly doesn't suggest, as I say, it's a relatively unlikely. I don't know if that's ever occurred in the control order context, because it doesn't seem to be very often the case that obligations are increased during the course. But if that happened, it will be dealt with there and could be dealt with here. That was the first argument. We say Court of Appeal was correct for the reasons they gave. It is directly determinative of the legality of obligation. The second argument is, well, if we're wrong on that, is the right of abode in any event a civil right? And it may help us to see how the Court of Appeal dealt with it. It's page 117. Paragraph 117 starts the reference to Pomiahowski. Then 117, the sentence that Mr. Tam took you to. Mr. Tam submitted that an order for extradition is not the same as TEO. That submission is right as far it goes, but that difference is not a sufficient reason for distinguishing an order for extradition and the TEO. Submitted with the sense both measures significant interference with the person's right of abode and with his right to come and go from the UK as he pleases. That being so considerable force in the submission, we're bound by Pomiahowski, but 118, 119, we don't need to determine the matter. And our submission is, if we're right on our first argument, the court may take the view that it doesn't need to determine the matter here in any event. But of course, I will make submissions on it because we may be wrong on our primary argument, the obligations argument. The starting point is that it's not understood to be disputed that the TEO, so now the question is, if we're wrong on that, is right of abode itself a civil right? Not disputed, as we understand, the TEO does interfere with an individual's right of abode. It clearly, at least in QX's case, stopped him leaving the country and returning as he wished because of the passport consequences. So the question is, I'll attempt to deal with make my submissions under three headings. First, what did Pomyahowski decide? 2, is it distinguishable? 3, if not, is there some very good reason for this court to depart from a previous decision of the Supreme Court? So first, what did Pomyahowski decide? You were taken to the decision, but it may be helpful just to turn it up again. It's at 1597 for the electronic buttons or and as the court noted, it's only the Halligan part of the case that we're concerned with. And the key paragraph from Lord Mance's speech, with whom Lord Phillips, Kerr and Wilson agreed, I'll show Baroness Hale's speech in a moment. The key paragraph is 31 through to 33. That's the conclusion that Lord Mance reaches, and it's...
That's page what?
1616, apology.
Good.
There's a distinction between, and I'll come back to whether this is a good distinction to draw, but the conclusion is a distinction between aliens and citizens. And his conclusion is the first sentence of 32, as a citizen, Mr. Howell enjoyed a common or civil law right to enter and remain in the UK as and when he pleased. And Baroness Hale's 1620, paragraph 49, right of a person to enter and remain in the country to which he is a national is the most fundamental right of citizenship. She notes at B, it's perhaps more question whether it counts as civil right. She says, as originally conceived, Article 6.1 did not apply to the rights enforceable only in public law, but that limitation has been steadily eroded. See jurisprudence discussed by Lord Hope. And in any event, the right is not like a claim to a social security benefit, which is a civil right, or a social service, which currently is not, for these can only be enforced as provided for by statute by judicial review. Should the need arise, the right could be claimed in ordinary civil proceedings against a person who was denying it. So that's the court's conclusion, is that the right of abode is a civil right. And you'll see the discussion there, the right encompasses enter and remain, but it's also clear that it encompasses a right to leave as well. You see that from a Gardaí, for the court's note, it's page 1206, paragraph 28. And of course, the right of abode, as reflected in the Immigration Act, is the right to live in, described as being the right to shall be free to live in and to come and go into and from the UK without let or hindrance. So that's the right of abode is enter, remain, leave, and then leave and come back. The second question is whether Pomyahowski is distinguishable from our case. And the Secretary of State's first submission in relation to that is he says it's concerned with different rights. This is paragraph 7.5 of the Secretary of State's written case. Concerned with different rights, Halligan was at the time in the UK and enjoying the right to reside in the UK. The proposed action involving his compulsory the proposed action involved his compulsory expatriation. In contrast, QX's situation concerns his right to enter the UK, in which he was not at the time present. And we say that isn't a good basis for distinguishing, because the right to abode does not only encompass a right to be present in the UK, it also encompasses the right to enter as well as the right to leave. And you can see that from Pomyahowski itself. Lord Mance, paragraph 31, spoke of the right to come and remain within the jurisdiction. 32, I showed you right to enter and remain in the UK as and when he pleased. Baroness Hale, right to enter and remain. And we do say it must be right that the right to abode includes a right to enter as well as a right to remain, because it's of little value if a person can't enter the UK in order to exercise the right. And a third reason we say that's not a good base of distinction is when one looks at Lord Mance's analysis at paragraph 31, all the cases he cites are cases where individuals were seeking to enter. My only friend said that Banco was concerned with removal, expatriation, but it wasn't. The case was involved, if one turns it up, it's page 1282. Right. One can see from the head note a lot of concerns. (1282) at G. You'll see that the challenges to these two 2004.
Sorry, 128.
1282, yes.
The head note.
The head note, yes. Just at G, you'll see the challenges to 2 orders in council. You'll see just above the G. June 2004, the government decided to reintroduce immigration controls so that islanders would no longer be allowed to return to the outer islands without a permit, therefore passed the 2004 orders. So the Banco was concerned with entry, not extradition, forced removal. Bagwan was also the other case cited. Bagwan was an entry case, and one will see, and the specific quote from Lord Diplock that Lord Mance quotes at paragraph 31 was the reference to the common law rights of British subjects to enter the United Kingdom when and where they please, and on arrival to go wherever they liked within the realm. And Van Duyn, I'm going to pronounce that Van Duyn, is a case about a refusal to admit a Dutch national and whether that breached EU law. But again, the quote cited by Lord Mance from paragraph 22 refers to the international provision that states are precluded from refusing its own nationals the right of entry or residence. So we do say it's clear that the right that the Supreme Court was thinking about was not simply the right to remain, it was the other aspects of the right of abode as well. And it is difficult to think of any logical reason why the right to remain would be a civil right, but not the right to enter in order to exercise that right. The second distinction the Secretary of State seeks to draw is that he says, well, Pomyahowski concerned a more serious interference with the right. He said this at 7.7 of his written case, page 53. Pomyahowski concerned interference of a different nature. The proposed extradition of Halligan would deprive him of a right of residence he was currently enjoying. In contrast, TO only amounts to a control to the exercise of the right of abode of which the individual cannot be deprived. And 7.8, third, Pomyahowski concerned interference of a completely different order, and again explains Halligan next right, he will be compulsory to deprive the right to reside. In contrast, QX right to entry was only modified by the TO in the manner in which he could exercise was subject to additional controls. And he also says elsewhere, notes the TO cannot deprive the individual of the right to abode. Again, we say those are not good basis of distinction in terms of the engagement of Article 6. First, a party doesn't need to show that a right's been extinguished before they can claim there's been interference with a right. Second, we of course accept that the interference with the right to abode in Pomyahowski was a more serious interference. That doesn't tell you whether Article 6 is engaged. You don't have to show a particular serious level of interference with a right for Article 6 to be engaged. 6 will be engaged in a contractual dispute, whether it's for £500 or £5 billion. It's not, that doesn't change whether whether a civil right is in play. What it might affect is what Article 6 requires if it's engaged. So that's the Tariq point, and what does fairness require may depend on the seriousness of the interference, but either right to abode is a civil right or it isn't. The level of interference with it doesn't answer that question.
So do you accept then that if a court were to conclude that, yes, the individual subject to the TEO is subject to obligations which just about interfere with his Article 8 rights, therefore Article 6 is engaged, that the amount of disclosure that he's then entitled to may be less than he would be entitled to if the obligations were much more onerous?
Yeah. Yes, we accept. I mean, that
does that mean that you accept that AF3 is not a fixed amount, that it has inbuilt in it a flexibility according to those kinds of factors?
not quite, my lady. If AF number 3 is required, that is fixed. It's a core irreducible minimum. Whether AF number 3 is required, we accept, will depend on the seriousness of the interference. So you could certainly conceivably have a case where, and that's why Mrs. Justice Farby and Mrs. Justice Collins in BB and CC go through a 2-stage analysis. They say, is Article 6 engaged? Answer, yes, these are civil rights. We've then got to go to the next stage and say, how serious is the interference? Is this AF number 3? So if it's an AF number 3 case, then core irreducible minimum, that's the Lord Phillips at 59. But it may be that it's not an AF number 3 case, in which case you're not entitled as of right to the core irreducible minimum. That's Tariq. So Tariq was the employment discrimination case where it was held, Article 6 was engaged.
Isn't bundle?
It isn't. It's referred to, I think, at 40 to 42 of the first judgment of Mrs. Justice Farby. But the Supreme, I think it's the Supreme Court on House of Lords, held that Article 6 was certainly engaged in the employment proceedings, but it wasn't, the nature of the interference wasn't such as to require AF number 3 disclosure.
Even though there was an interference.
Even there wasn't, yes.
So it's a threshold as to whether it actually amounts to an interference.
Yes.
But then there's a further threshold as to whether it in fact justifies AF3.
Yeah, precisely. And that's, I think, that was all disputed before Mrs. Justice Farby in her first judgment about were the obligations sufficiently onerous to, did they constitute civil rights, and then if so, and that isn't now challenged. We also say that in our case, it's not the case that the interference with the right to abode is a trivial one in any event. Obviously, in some cases there'll be interference with the permit of return, but we do say not allowing someone to leave the country is a reasonably serious interference with the right of abode. So our submission is that what Pomiahowski establishes, we say clear, one can see it in the judgments of Lord Mance and Baroness Hale. We also say, given that it applies, we say clearly from the judgment to entry, remain, we say it must apply to leave as well. That's all past the right of abode. The question is, should the court depart from Pomiahowski? I think the Secretary of State ultimately did not invite you to depart, as we understood his submission yesterday, to depart from it. I think he said it wasn't clear, the ramifications would not be sufficiently clear if the court reached that decision. But I will address the court on the issue nonetheless.
Well, I think he said if push came to shove, he would actually ask us to.
He had in writing, and I thought, then in which case I will deal with push come to shove. The test we set out, as will be very familiar to the court, particularly with Dalton having been decided relatively recently, we set out the test for departure at 78 to 79 of our written case, and any of that's controversial. It starts with the 1966 practice statement, which states that, of course, that was when, for the first time, the House of Lords it could depart at all from previous authorities. And what it was said, it was still, it would be normally appropriate to treat previous authorities as binding. And we also quote, you'll see in our written case from Nuller, there are again many authorities that deal with this, and what that makes clear is it's not enough that the court should think that the decision was wrong. There needs to be some very good reason before the court will act. This is Lord Reed in Nuller. I think that however wrong or anomalous the decision may be, it must stand and apply to cases reasonably analogous unless or until it is altered by Parliament. And that was again picked up again. The court, we haven't included Dalton in the bundle, but again, the point made there is the fact that this court might reach a different conclusion if dealing with the matter afresh is not in itself a sufficient reason to depart from a previous authority. Applying that to the present case, Pomyachowski is a relatively recent unanimous decision of the Supreme Court, and it's not suggested that it's called that any social or legal developments require it to be revisited, not suggest it's caused any difficulties in practice, and it's not suggested there's some recent Strasbourg authority or other legal development that requires the case to be revisited. We'll see what's said about earlier Strasbourg authority. What is said is that the decision was wrong, effectively. But we do say, well, the question for the court will be, does that satisfy, and even if this court concludes that it was wrong, it might have reached a different decision had it been decided afresh. Does that give rise to a sufficient very good reason to depart from a previous case with the consequence that has for precedent? Obviously, this is a precedent potentially affects a series of different areas, as well as extradition, a range of other areas in which the right of abode is at issue. Dealing with the three arguments the Secretary of State made in his written case as to why Pomyachowski was wrong. The first relates to the relationship between the common law and the statute. And he says that the error made by the Supreme Court in Pomyachowski was to analyse this as a common law issue, when in fact right of abode is now contained in statute. And all respectfully, and that isn't certainly is a valid reason for departing from the Supreme Court decision. And one can see why, if one looks at, if one goes back to Banco, the Chagos Island case, 1, 2, and 2.
Sorry, page.
1282. It's the start of the case, and then key paragraph again is in Lord Mance, paragraph 151, which is at page 1348. And I should say he was dissenting, but I don't think any.
So what was the page number again?
1348. He ultimately dissented in this case with Lord Bingham, but I don't think this alters this now. And of course, he was then the lead judge in Pomyachowski. If you, Mr. Crowe, who's there for the Foreign Secretary, submits nevertheless that the Crown subjects inhabiting BIOT, the British Indian Ocean Territory, had in public law no right of abode, and nothing of which they could therefore be deprived. As common ground, this would not be the position in the United Kingdom. Right is fundamental, etc. And he quotes many of the same things he later quoted in Pomyachowski. And then if one looks at the end of the paragraph, towards the end, he discusses the statutory changes that are made around E. Thus, from 1973, when the Immigration Act came into force, all common citizens entering the United Kingdom without leave were liable to prosecution. But the common law right to enter and remain within the United Kingdom remains unchanged in respect of those with British citizenship based on their connection with the United Kingdom. And the reason he says that is if one turns up the Immigration Act, Section 1 makes absolutely clear that the right of abode of British citizens is the right to be free to live in and to come and go into and from the UK without let or hindrance, which is precisely the common law right. So the right's unchanged by the Immigration Act. There are other people who've then had the right removed from them, but British citizens retain the right. It's exactly the same as the common law right, and it doesn't matter. We say it can't matter for Article 6 purposes whether the right is a common law right or the right is a statutory right. It's the same right. The question is whether it's a civil right, not what the source of it is. The Secretary also argues, or a related point, is this is 6.2 of his written case. He says the right of abode is a measure of immigration control. We say that's analytically wrong. The right of abode in the Immigration Act is a right to be exempt from immigration control. Everyone else, this is Section 1.2 of the Immigration Act, can only live, work and settle in the UK by permission. That's the immigration control. Someone with a right of abode has the right to enter freely, etc., unless removed by statute.
Yeah, I haven't looked at this for a long time, and I can't remember if it's discussed it, for example, in Blackstone. But my feeling is that the right is derived from the relationship between a subject and the monarch, and it's the counterpart of the obligation of loyalty which the subject owes to the crown.
Well, again,
common law.
Yes, that certainly sounds right, but I haven't looked at it either. But in terms of the content of the right, which is what will tell us whether it was civil or not, the right is the same. The key dispute here is not, no one doubts, as I understand it, it's a right of constitutional importance. The only question is its civil nature, and therefore whether it falls within Article 6. The Secretary of State's second argument...
Presumably civil nature under the autonomous meaning.
Yes,
yes,
precisely, yes. That's what I meant by civil, rather, yes, not a sort of criminal civil dispute. Yeah. Is it civil as... Is it a civil right as Article 6 understands a civil right, is the key question. And the Secretary of State's primary submission is in effect that the court erred in distinguishing the position of nationals from the position of aliens, or at least they should have been treated, that the Maoria decision that the rights of aliens not to be removed from the country, not being a civil right, the argument is, well, that ought to have been applied equally to citizens. And it's further suggested that this was an expansion. This was the Supreme Court expanding Article 6. We say, and that was the reference to A.B. and Lord Brown, etc. There is a question, though, whether that's the correct form of analysis here, because I'll take you in a moment to two Strasbourg authorities. The way the Strasbourg case law has developed is that there are a series of areas that are excluded from Article 6, and they're relatively fixed areas. We'll see in a moment: taxation, deportation of aliens, certainly one of them, right to stand for office. The question here is not quite the same as the normal expanding on the Strasbourg jurisprudence. The question is, should the domestic court recognise another category of exclusion? or should it expand the Mauia category of exclusion? And we will say, we'll look at the Strasbourg Authority as a moment, which is taking the Strasbourg Authority beyond what Strasbourg has held. We do say that we'll look at there's the one Spanish case we will look at, but we do say, in fact, what's happening here, the analysis is, should you expand Mauia so that it applies to nationals as well? That's what Lord Mance was not prepared to do. Before taking to Mauia, again, it may help just to go back to Ferrazini and to show you another case, Di Tomasi. You were taken to Ferrazini. It's 1858 of the bundle. And the key point, well, friend, it took you through the key analysis. It's 23 to 30, page 1863. But what the underlying this, and we'll come, and this is the point that Baroness Hale noted in Pomiahowski, is that the traditional view had been that public law rights were excluded, but what you see is the court, this is the paragraph 26, convention is a living instrument, incumbent to review in the light of changing attitudes. Relations between the individual and the state have clearly developed in many spheres during the 50 years. Moreover, the state's increased intervention in individuals' day-to-day life in terms of welfare protection, etc., has required the court to rethink. But, they say, Ferrazini, there remains a hard core of public authority prerogatives, which is where taxation falls in, as does, in the paragraph above, you'll see the number of other well-established categories, political rights and obligations, etc. And then you'll see the Mauia situation, the aliens, expulsion of aliens, footnote 12. And we'll also see the same type of observation in the Di Tommaso case, which you have at 1704 of the electronic bundle. And we'll see in a moment, this is much closer to the situation we're concerned with. If you have the head notes, you'll see what this case was about. Bari public prosecutor, remember the Bari District Court placed the applicant under special police supervision for 2 years, imposed a compulsory residence order on him. This is because of his previous convictions, regarded as dangerous individual. The court imposed a preventative measure which included a number of obligations on the applicant, such as weekly reporting to a police authority, curfew and residence at a specific address. And turning further into the judgment, the analysis of Article 6, you'll first see page 1736, paragraph 144. You see a very familiar paragraph. This is the same paragraph in Regner about the engagement of Article 6, directly decisive, right, the result must be, etc. The court then analyses 147 to 152, and what it notes is, and this is an expansion much closer towards what we already think of public law matters. This was how people are treated in prison in particular. 151, the court therefore observes there's been a shift in its own case law towards applying the civil limb of articles to a case which might not initially appear to concern a civil right, but which may have direct and significant repercussions on a private right belonging to the individual. And in particular, the concern here, you'll see 152, is in fact with the residence. The court refers in particular to the requirement not to leave the district of residence, not to leave home at certain times, not to attend public meetings, are the particular civil rights that the court identifies. And the difficulty we say, or the difficulty or response to the criticism the Secretary of State makes of the Pomiahowski judgment is that other than the Mondero Angora case, which we'll turn to, there is no other Strasbourg authority that deals with the right of abode. I'll go briefly through the other the other cases, but we'll see that that's not what any of those cases are concerned with. And this is in a context in which there has been a development of the Strasbourg case law towards recognising more and more rights that would ordinarily appear to be public law rights, rights not to leave a district of residence, as civil rights. And so the question is, was the Supreme Court entitled, or was it so badly wrong not to recognise removal of a British citizen? Was it wrong not to say that's also within the excluded category, the Maui excluded category? And in relation to that, we say one can see why, or good reasons not to think that analysis is wrong. If one turns up Maui, it's page 2046. We've gone to 38, which is the incidental consequences point. But where the court, before reaching the conclusion, or the basis on which the court reached its conclusions, 2053, paragraphs 33 to 37, and what one will see is that the key to the analysis, starting at paragraph 36, the court points out the provision of the convention must be construed in the light of the entire convention system, including the protocols, refers particularly to Article 1 of Protocol number 7. And we'll turn to that in a moment. But what that does is it accords specific procedural rights to aliens facing expulsion. And so the reasoning of the court is, well, if you read the convention as a whole, it cannot have been envisaged that Article 6 would apply because the state parties have created a bespoke procedural right. It has lesser protections than Article 6, but they wouldn't have needed to create that bespoke protection if Article 6 applied to aliens. And if one turns up, there's a quotation from the explanatory report, but if one actually, they don't quote from the Protocol 7, Article 1 itself. It's in the additional bundle, page 7. This was the bundle that was provided to you later on. We'll see the
Page 7 or tab 7?
Page 7 of the Supplementary Authorities bundle. And you'll see it's a very much a procedural right. Alien lawfully resides on the territory shall not be expelled except in pursuance of a decision reached in accordance with law, and shall be allowed to submit reasons against his expulsion, have his case reviewed, be represented, etc. So it's very much a procedural set of rights. And the logic of the Maui case is, well, that wouldn't have been necessary. Read it as a whole. This is the code for aliens. You wouldn't need any of that if Article 6 applied to them. Now, the analysis, the position would be, if the Secretary of State is right and that you treat citizens in the same way as aliens when they're being removed from the country, what that would mean is that the state parties of the convention have created significantly less rights for citizens being removed than they have for aliens being removed, because obviously nationals being extradited do not come within Protocol 7, Article 1. It's very much it's aliens lawfully residing on the territory get these rights. The Secretary of State referred to Article 3 of Protocol 4, which he took you to, which says no one shall be expelled from their territory, from the territory of the state from which he is a national. But that doesn't apply to extradition, because, of course, if it did, if expelling was the same as extradition, then no one could ever be extradited. And we know that it doesn't apply to extradition from HF and France. Electronic bundle, page 1957 at paragraph 247. So the Secretary of State's submission, or if Pomyahovsky was wrong not to apply Maui, the consequence would be that nationals being extradited would have less rights, less procedural rights under the convention than aliens being expelled.
But any state that's ratified this protocol can apply the same procedural protections to their own nationals in their legislation. There's nothing in the convention that stops them from doing
Nothing to stop them, but if one is reading the convention as a whole, which is what Maori does, the consequence would be states are protected aliens with giving them, according to these procedural protections, but there is nothing in the convention, if Article 6 doesn't apply. My lady's absolutely right, one can, and of course we do have proceedings under the Extradition Act, but if one is looking at the convention as a whole, which is the Maori analysis, the analysis is, well, this provision shows that Article 6 doesn't apply, because that's why it was felt it needed to be enacted, but the consequence would be that a citizen being extradited, if Article 6 doesn't apply, has no protection under the convention. And we do say that would be surprising if that was the decision that states had taken. There's then a further reason. Well, I've already took you to Baroness Hale's explanation of why the right was a civil right in paragraph 49, but there's also a further one which I accept isn't discussed in Pomiohovsky. But if one's looking at more recent developments of the Strasbourg court, we saw that in Di Tommaso, the court considered the requirement not to leave the district of residence was a civil right in that case. It would seem odd, we would say, if freedom of movement within a country was a civil right, but freedom to leave the country was not a civil right. It does seem an odd distinction to say it's a civil right to say you can't leave this area, you can't leave this county, but if you say you can't leave the country, that is not a civil right. Now, it makes sense in relation to aliens. This was the point that Lord Mance makes in Pomiohovsky, because there is that, one can see why protection of borders, deciding which aliens can come and go, is a hardcore public authority prerogative. One can see one will make that distinction, but if one is talking about nationals who do have the right otherwise to come and go as they please, if it's a civil right within the country, our submission is it's odd to see why it's not a civil right to leave the country. So on that basis, again, these odd submissions I'm making, because of course if we were deciding this afresh, the court might have a different, but certainly in terms of can one look at Pomiohovsky and think this is so wrong that we have a very good reason for overturning it. And our respect position is there are certainly, we say with respect, good reasons to think it may well have been correctly decided.
Baroness Hale, I mean, it seems to me that part of the problem with Pomiohovsky is it might be said the Supreme Court hasn't explained the Strasbourg jurisprudence that leads them to say it's a civil right. But there is a reference by Lady Hale at page 1621 to the jurisprudence being discussed in the Alley and Birmingham City Council case by Lord Hope. Does that actually, are you relying on that in any sense? Does that get you anywhere?
I have to be honest, I haven't chased it. I think what she was relying on it for, but we perhaps should have chased down, was, I think that was to do with benefit entitlements when looking round, but so we're not relying on it in that sense. I think what she was relying on, Lord Hope, for is simply the way in which the concept of civil right has expanded. I don't think I can't. No, the case was. I don't think the case wasn't a right of abode case in that sense. Finally, the Strasbourg Authority. The Secretary of State relies on a series of different cases. I'll try and take them relatively quickly because, in fact, all of them other than Mondero Angora are not involved, do not concern the right of abode at all. But we also make some general observations about them. Firstly, they're all admissibility decisions. They're all at least, I think 16 years old is the most recent one, some considerably older, and that's relevant given what we've seen about the way in which Article 6 has changed over the years. And they're also cases which have barely any reasoning. They tend to be a single sentence, which the court simply asserts a conclusion. I'll attempt to take you through them rapidly. First one, Peltonen and Finland, which you have at 2095. So this, again, it's a very old case, 1995 case, but it's not a right of abode case at all. This was a man in Finland who wanted to get a Finnish passport but wasn't allowed to. He was living in Sweden, and if one looks at 2098, you'll see under the paragraph 3, in fact, he can go into Finland and out of Finland and back into Sweden because they're all Nordic countries. He doesn't need a passport. So really, this is about, if he possibly wants to go to other countries. So this isn't a right of abode case at all. And the reasoning 2103, again, we'll see this in most of these, I think all of these cases, the entirety of the reason is the Commission cannot find this right was civil, given it was not as such of a pecuniary or otherwise of a private law character. That's the entire reasoning. But in fact, as we've seen, that was de Tommaso. The law has moved on in Strasbourg from saying private law character pecuniary to extend to all sorts of rights that one ordinarily think of as public rights. Smirnov 2224. This is again a passport case, a Russia passport case, but it appears that the reason he wanted a passport, it was no suggestion it was to travel, he wants it because it proves his residence. And you see it 2226, just under the 3, the problem was without him being able to prove his residence, he couldn't hire cutlery and a folding bed, and over the page, couldn't enter a contract with a telecoms provider under 4. And again, the reasoning 2230 is the identical single line. Karasev and Finland, I don't have time to take you that, but again, it's a single line there about Finnish citizenship. Same single line. Harrison, which is the British case about citizenship, the court leaves open whether it's a civil right. The closest the court comes, paragraph 29 of Lord Justice Keene's judgment, is to say, if he had to decide the matter, he would have said Article 6 is not a civil right, the right to citizenship, but in fact he decides it on a different basis, which is that it wasn't being determined by the Secretary of State. It's a matter of fact for the court. That's paragraph 34 to 37. And Lord Justice May expressly doesn't decide the Article 6 engagement front. What that means is that the only case that deals with this is the Mondero Angora case, which is the Spanish extradition case. And you were taken to the entire reasoning in that, which is simply an assertion with no explanation at all. It just says Article 6 not engaged. And our submission is that that does not provide a sufficiently good reason to depart from the Pomyakhovsky case, that suite of jurisprudence, particularly, as I say, when one puts in the context of the expansion of Article 6 rights and the de Tomasi, etc., line of authority. Wills Lady, unless I can assist further.
I just have one question. If we were to decide that Article 6 does apply, what is the order that we're being invited to make? What would be the consequence of that?
I think the order would be it would simply be a declaration, I think, which is the same as the Court of Appeal made.
And what would the consequence of that declaration be?
That would mean that Article 6 applies to...
No, I know. What would be the consequence for this case?
It would mean, Article 6 would certainly apply to conditions A and B, because no one disputes them.
Yes, but would it have to be remitted back to somebody to decide?
I think in any event, this case is still a preliminary issue. So in any event, this case will have to be remitted back to whoever is deciding it to work out what to do with the conclusion if Article 6 is engaged. What disclosure is then required would then need to be decided, because the reason the Syria allegations weren't disclosed was because of Mrs. Justice Farby's analysis. If that's incorrect, Article 6 is engaged, she or whoever's dealing with it will have to decide what flows from that in terms of disclosure.
Thank you.
Thank you very much, Mr. Squires. Mr. Tan.
May it please the Court. I'm grateful for the opportunity that we've had to put in the note. I hope that that in itself has been comprehensible, and we invite the Court to read that carefully. Because these are open proceedings in this court, we have been very careful to try not to refer to the word closed at all. And having now trespassed slightly over that line, can I please orally make clear that nothing should be inferred from any of our submissions about the content of the closed evidence, because that is not something that we are touching on at all. We had tried to argue this appeal purely on the matter of principle. It is an important point of principle. In any individual case, of course, what happens, and including in QX's own case, when it goes back to the High Court, what actually happens will be a matter that's very fact-specific. But there is an important point of principle for all future TEO cases involved here, and that is why we're addressing this. A second reason why we're grateful for the opportunity to put in the note is that I think it's rather crystallised the source of the confusion that there was yesterday about what exactly our position was in relation to disclosure in the two different sets of proceedings. The first, I think I did use the word fallacy yesterday because it was a suggestion that had appeared in Malone & Friends' printed case. The fallacy that there is the national security case, and that is what underlies both sets of proceedings. It is with respect to fallacy because, well, for the reasons that I touched on yesterday, of course, simply from the statutory scheme, the national security cases are likely to be different because of time and content restrictions. But second, because what is invisible to participants in the open proceedings is what the content of the closed evidence might be. And that might be different as between the two reviews, even if the open disclosure is in exactly the same terms. And therefore, we respectfully say that there is no way well, certainly for an open representative, the individual's open representative, to say, well, I have or I do not have AF number 3 disclosure of the Syria allegation. That is, whether or not that is true is something that can only be decided by an examination of the closed material in each of the two sets of each of the two reviews, and that can only take place in closed. And so, with respect, our position has not changed, certainly, and none of us on this side thought I'd said anything unusual yesterday, and I hope that the note has now gone some way to explaining exactly why, at paragraphs 26 to 29 of her third judgment, Mrs. Justice Farby was able to set out very clearly why conditions A and B could only be decided in the imposition review, but that does not exclude an examination of national security matters that are relevant to the necessity and proportionality of the obligations when the court comes to look at the obligations review.
But it is your case, I think, that if somebody just brings an obligations review, can they or can they not say, I challenge these obligations on the basis that condition A was never met?
We would say technically no, but they might very well be able to say, I challenge these obligations because I am not and I have never been a terrorist and I've never been engaged in any TRA anywhere. And therefore, the obligations are simply unsustainable.
Well, that seems to be different from the position you took before Mrs. Justice Farby. If that's your position.
Well, that is our considered position. We do not think that we could properly shut out an individual who's challenging his obligations from advancing that argument if he wishes. In an individual case, there might be forensic points to make about, well, why aren't you challenging the imposition of the TEO if your case is so fundamental that you are not a terrorist at all? And one of the reasons for the procedural tangles in the present case is that QX's factual case is one which he could have advanced by way of bringing an imposition review and an obligations review at the outset. If he'd done that, we might not have had quite a lot of this messy knitting, the procedural knitting that has gone on. So finally, he comes to bring the imposition review, and we start all over again looking at the Article 6 applicability to that. So
he can challenge then. Technically not, but in reality, in practical reality, he can challenge condition A in an obligations review.
Well, he can challenge the substance. He can challenge the national security matters that are relevant. And that may involve him saying, I'm not a terrorist, I've never been a terrorist. And then the court will look at the open and closed material relevant to the obligations review, because that would be a matter for the Secretary.
That's where you then slide off a bit, respectfully, because he may say, I'm not limiting my challenge to the condition A to just what you now choose to rely on to impose the obligations. I want to challenge what you relied on to impose the TEO in the course of my challenge to the obligations. So
well, then we
determines the scope of the material.
Well, then we say if he wants to challenge the TEO itself, the imposition of the TEO, then he must bring an imposition challenge, imposition review. That's what the statute says, because only then would the court have power to quash the TEO.
So is your point the legal question as to compliance with conditions A and B does not arise on an obligations review, but that the same substantive subject matter can be canvassed?
Yes, I think that's right. And for these purposes of these open proceedings, it may involve the individual saying the same thing, I'm not a terrorist. But in closed, the court will be looking at the material that the Secretary of State chooses to put before the court in the closed proceedings on the obligations review, which may or may not be the same as the closed material that would hypothetically be put before the court on an imposition review.
Can I just see if I'm understanding something basic here? the review is based on judicial review principles, the Act tells us. So the review has to be brought, I presume, on the basis that the Secretary of State's decision to impose the obligations is Wednesbury unreasonable, or has taken account of irrelevant considerations or something of that, something within the Wednesbury framework.
Well, it's wider than that because of the influence of ECHR rights.
Oh, I see. So judicial review principles include human rights principles, do they?
Well, certainly when necessity and proportionality are looked at in an obligations review, then compatibility with convention rights is, certainly something that's frequently looked at, and the reason for saying that is because in court there are some things that the court must decide for itself, and it isn't just going back to conventional common law Wednesbury principles.
Where do we find necessity and proportionality?
I don't think it's expressly set out in the Act.
I mean, what the Act says is, on a review, the court must apply the principles applicable on an application for judicial review.
Yes, but because convention rights are involved, questions of necessity and proportionality frequently arise, and then the court must examine compatibility with convention rights in accordance with judicial review, the judicial review approach to convention challenges. And that is wider than a non-convention traditional common law approach.
So you tell me. I wonder why one needs to get into the convention at all on this. But
yes,
there we are. In any event, the onus, I take it, is on the individual to make out his challenge.
Yes, well, technically that is right, but there's only a limit to what he can do. So
that's what I'm getting at. I mean, your submissions assume the Secretary of State is in charge of this process.
Yes.
And I'm not at all convinced that's right. Well, the Secretary of State has, when one goes, we haven't been taken to Schedule 3 to the Act, but that lays out the framework for the making of rules of court. And they're designed, I think, essentially to protect the Secretary of State from being compelled to produce information or evidence that needs to be withheld, or what he judges or she judges needs to be withheld. But effectively, he has to concede the point if he chooses not to lead the evidence.
Yes.
But subject to that, is one not in conventional JR territory in terms of the need for, or the ability of the claimant in principle to, if evidence is required, to obtain the evidence?
But, there is more than just the limited amount that the individual and his open representatives can do. Because when we go into closed, what happens is that the special advocates, having got the steer from the individual about what the individual's case is, then pick up the ball and run with it. And they are the people who do the work of examining the closed evidence to shake the Secretary of State's case, to argue the points that are in support of the individual, and to discharge their statutory function of representing the individual's interests in the closed proceedings. And special advocates' work is absolutely crucial to how all these closed material procedures operate, because the individual can't take part in that. And that is where a great deal of the work is done in the CMPs.
But still, in the closed material procedure, I presume ordinary rules apply, and those acting on behalf of the claimant are entitled to apply for the disclosure of relevant material, and in principle, the court will order disclosure subject to the protections that are given to the Secretary of State by the rules of court.
Yes, and even if the requested material can't be disclosed into open, it will be disclosed to the special advocates. And indeed, special advocates are frequently asking us for disclosure of all sorts of things, both into open and into close. So there's a great deal of evidential work that goes on. But the overall content of the case is that which is chosen by the Secretary of State, because the national security case is really for the Secretary of State to make out. For the purposes of the linkage and the extent of the linkage between the two reviews, that's the imposition review and the obligations review, we respectfully say it is important to recognise that not only are they different legal proceedings examining different decisions of the Secretary of State and with different outcomes, that's all prescribed by statute, there may very well be different substantive sets of evidence for the two proceedings.
Yes, I can see that, but is it if QX wants in an obligations review to say I was never a terrorist, the Secretary of State knows that they're going to have to give AF3 disclosure. They may choose to put before the court a subset of what they relied on for the imposition. But is the court then to determine whether he was ever a terrorist on the basis of the evidence on which the Secretary of State is relying in that hearing? Or can the Secretary of State say, well, there was other stuff that we relied on, but we're not prepared to say what that is?
Yes. If it's only an obligations challenge, the court can only look at the material, the subset of material that's been put before the court for that review. If there's an imposition challenge, then for deciding that, the court could look at what on this hypothesis would be the fuller set.
But I think you accepted a little while ago that in the obligations challenge, the court could say this TEO should never have been imposed. They can't formally, I think you said that in answer to my Lord Lloyd Jones, they can't formally quash the order, but they can quash the obligations on the grounds that they're not satisfied that QX was ever engaged in terrorist-related activity. And it may be that that is a different decision from the decision they might have arrived at if they'd been able to see more information that the Secretary of State might have been prepared to put before the court if AF3 did not apply. But that's how it's...
Yes, and I accept that that is a possibility if Article 6 applies to the obligations review, but not to the imposition review, and the two sets of evidence are different. I accept that is a possibility.
With different results? With different results?
Well, there might be different results, and
from the same judge?
Yes, if that is the way that is being case managed. And Malone and Friend raised this possibility with the description incoherence, and I said that I would come back and reply to the way that he'd argued it. We respectfully say that this is not incongruous, let alone incoherent, where you have two different legal proceedings that have two different sets of evidence. And there may be different results. So the different results that might occur on the evidential hypothesis that my lady puts to me is that the TEO is upheld, but the obligations are quashed. because they could not be supported with the subset of evidence. That's the hypothesis that was put to me. This is, we respectfully say, but well, it's not usual, but it's not unknown. There is an analogy from just general legal work, which is where you have the same issue being decided in a criminal case and in civil proceedings, because the different standards of proof may lead to different results, even if it is substantially the same set of evidence being looked at. And we know that there are some high-profile cases where people have brought civil proceedings to establish something which could not be established in a criminal case. So this is far from being unknown. Even within the national security field, there is an area where this is it is possible that this can happen, and that is the deportation and detention pending deportation. It was looked at in MT Algeria. Chahal was the basis for the House's decision in MT Algeria, and then it's referred to in Pomachowski in the passage that I showed you yesterday. It may well be that deportation, there's a perfectly good national security case for deportation, doesn't have to comply with Article 6 or Article 5.4, but it is not possible to detain the person pending deportation because the national security case that can be relied on for the purposes of detention must comply with Article 5.4. And that may reduce the evidence to a subset of the material that can be relied on for deportation. In one sense, this is exactly the same pair of different results.
Is that substantively different result? I mean, in this case, you're envisaging an absolutely different substantive result.
Well, but with respect, the statute prescribes that these would be different results anyway. If the TEO, if the imposition review succeeds, the TEO is quashed. But if it fails, the TEO is upheld. In an obligations review with a different set of evidence, all that the court can do is effectively quash the obligations. So the result is going to be different anyway, and this is just a consequence of the fact that these are two separate sets of proceedings. And even though proceedings A have an influence on proceedings B, they are not sufficiently linked. And it is not incongruous that they may produce different results. In those circumstances, we respectfully adhere to the submission that I outlined yesterday. I said I would come back to this. In G and X school, just give you the reference again, it's page 1401. At paragraph 67, which is page 1427, Lord Dyson referred to the Strasbourg approach of pragmatically identifying categories of case. And we are in the territory where, because of the linkage, but not a complete decision, completely decisive decision-making, we are in the territory where neither my learned friend nor I have a slam-dunk answer. We are somewhere on this spectrum of cases where proceedings A have an influence on the outcome of proceedings B. The closest analogy that one can find in the Strasbourg jurisprudence is still the Mawia principle. Mawia itself may be some time ago, but the principle has been repeated consistently and has not been departed from all through these years. An immigration measure is, or rather a challenge to an immigration measure, is not subject to Article 6, even if it may have dramatic repercussions on Article 8 rights. So we respectfully say that that is the approach that this court should adopt.
My understanding is that the respondent says there aren't two proceedings, but assume for one moment there are two proceedings or two phases in the same proceedings. The test in RG is page 1427, paragraph 69, and that is will have a substantial effect on the determination of civil right or obligation.
Well, that would be on the assumption that there is really one single common law type test that can be applied. And that is why we respectfully draw attention to what Lord Dyson had said in paragraph 67. Strasbourg too has the mantra, that's a word that he used, but it actually adopts a pragmatic, context-sensitive approach. Not possible to classify all the cases into neat, hermetically sealed categories. And despite the difficulties, that is the approach which should be followed, and we respectfully say should be followed here. And as I say, looking for the closest analogy, that is indeed Mawia. And I should say, of course, we adhere to the submission that these are two separate proceedings because that's what the statute says.
But what broke the substantial connection between the school disciplinary hearing and the barring decision in G?
Was the fact that the ISA basically did its fact-finding itself.
Yes.
Yes. And you'll see that from paragraph 79 and 83, which are on 1430 and 1431.
And how, if at all, does that apply in this case?
Because the obligations review, which is our proceedings B, will be looking at a different set of decisions to challenge, obligations not imposition, may have a different set of evidence, and may therefore reach a different substantive result. That breaks the chain, or sufficiently breaks the chain.
But in RG, the ISA had an obligation to make its own decision about the substantive allegations.
Yes.
And you say on the obligations review, it does or doesn't.
The judge does have the obligation of making his or her own decision on the evidence that's adduced in the obligations review. And if it's different and it leads to a different result, then that is what happens, and then the outcome will be the TEO is upheld, but the obligations are quashed. The practical effect may be that the man doesn't have to go and see the imam or doesn't have to report to the police station, but he won't get his passport back. And so the scheme still has force, while complying with Article 6 where it needs to comply with Article 6. Lords and Ladies, can I just say one thing on the second topic, which is whether the right of abode is itself a civil right? It's a small point, but it's simply to note that a TEO does not prevent you from leaving the UK. You might end up in breach of an obligation if an appropriate obligation were imposed and you would have to breach that, but the order itself doesn't prevent you leaving. And section 47B actually contemplates you might do, because you might have to get another permit returned to come back.
But how does that impact on whether it's a civil right? That's about whether the measure is intrusive.
Yes, it was just because learned friends said that as part of how intrusive this is, you can't even leave it prevents you from leaving the UK. Technically, that's not actually right, and that's the only thing I wish to draw to the court's attention. Other than that,
if you've got another passport,
Yes, of course, you might have another passport, or, well, these days, one sees is not necessarily even necessarily requirement even today to travel. But yes, certainly, many people have another passport and be able to do so regularly.
Well, you can travel to the Irish Republic, but I'm not quite sure where else you can travel to without a passport. But anyway.
Probably better that I don't speculate on any of that. But other than that, on this topic, the court has our rival submissions, and I don't think there'll be any point served in my going through any of that. So unless I can assist any further, this stage.
I think not, Mr. Tam. The court is most grateful for your assistance and Mr. Squires and that of all the other people who have been involved. We'll take time to consider the submissions, and which may be some time, and we'll let you have our judgment in due course. The court will adjourn.